raising employer raising employer awareness and understanding of these laws. So it has been really great partnering with the Department of Labor on this initiative. And, I've had the opportunity to get out in front of so many different groups of employers and talk about these things. So I'll tell you, it's quite special for me to be talking to the YMCAs because a fun fact about me is that one of my very first jobs was working for a YMCA. I actually worked for the YMCA in Montclair. This was a lifetime ago. I was in high school, and I started off in, watching kids while their parents dropped them off while they headed out to exercise. Then I worked for the summer camps. I did the after-school programs. I was with the Y for quite a long time. So I'm so happy to be back and, be training in this capacity. It's one of those full circle type of moments. So again, going back to New Jersey's mandated benefits, New Jersey is quite unique in mandating these types of benefits. Most states do not. And navigating through this can be tough. So I hope to be able to provide some clarity today. And of course, field any questions that you have. So please, if you have questions, feel free to either drop them in the chat. I'll try to keep my eye on that. Use the hand raise or really just unmute yourself. We're a relatively small group, and I feel that we all benefit so much when we can have more of a discussion and Q&A. So feel free to interrupt me with your questions as they come up. And let me see if I can navigate these slides. Okay, so these are the three laws that will form the basis of our discussion today. Both temporary disability insurance and family leave insurance provide for monetary benefits when an employee is unable to work due to certain events. Disability, obviously, when the employee can't work due to their own non-occupational injury or illness, right? Non-occupational. If it was occupational, we'd be talking workers' comp. So we're not talking that today. And family leave insurance is when the employee is unable to work because they're caring for an ill family member or bonding with a newborn. Now, both of these benefits are paid by the state of New Jersey through the Department of Labor, unless you're an employer who has established a private plan. So I know that many of you are from different YMCAs. Perhaps some of you may have established a private plan for disability benefits. With disability, there's a lot of reasons why an employer may go with a private plan instead of the state plan. There's continuity of claims administration. There might be the opportunity to have some cost savings, and claims are typically paid out and processed a little bit faster when you go with a private plan versus the state plan. Much less common to see a private plan with family leave insurance. In fact, I've yet to come across an employer who offers a private plan for FLI. And the reason for that is that family leave insurance is fully employee funded, right? So employers don't pay into that at all. So why establish a private plan and have to start paying a third-party administrator when you're not paying for this now at all? What you're doing, and we'll go through the employer responsibilities, but essentially your role here is to withhold the payroll taxes from the employee's paycheck and submit them to the state. But if your company has opted out of either of these state plans, the private plan that you offer would need to be at least as generous as the state plan. So the state plan, it sets the floor. So everything that we talk about today would have to be in your private plan as well. We find that private plans tend to have a more generous benefit, but they could not have a less generous, right? So the state plan sets the floor. And again, even if you had a private plan, everything we talk about today would apply. Procedures might be different. The forms may not be the same. How employees apply would be different, but the baseline benefits and eligibility would be equal. New Jersey earned sick leave is a bit different in that it comes directly from the employer, and it requires that most employees in the state have access to up to 40 hours of earned sick time in a benefit year. Temporary disability has been around seemingly forever. It was actually established in the 1940s, if you can believe that. FLI has been around for just over a decade. Actually, I'll tell you, it's 14 years. And I remember that so specifically because my daughter was born 16 years ago, and there was no FLI available in New Jersey. And then my son came along 2 years after that, and I was truly one of the first to be able to take advantage of claiming these benefits. The benefits became payable in New Jersey as of July 1st, 2009, and my son was born on July 9th, 2009. So that's my story. I'm truly one of the first cohorts to be able to apply for and take advantage of these benefits. And New Jersey Earned Sick Leave is the newest of the bunch, right? So this was enacted back in 2018, so not that old at all. And when it comes to employees needing time off of work here in New Jersey, there are a lot of laws that could come into play. So I like to start off with this slide showing that there are certain laws that provide for job protection, and then there are other laws that provide for monetary benefits. I'm sure that most of you on the line are familiar with the federal FMLA, the Family Medical Leave Act. New Jersey also, of course, has its own Family Leave Act, the NJFLA. These are two laws that provide specifically for job protection to eligible employees working for covered employers. And then we have the ADA, the Americans with Disabilities Act, the LAD, the New Jersey Law Against Discrimination. These are not leave laws per se. However, an employer could be required to provide a leave as an accommodation to an employee who had a disability. The New Jersey SAFE Act provides for time off for those who are victims of domestic or sexual violence. We're not getting into any of those laws today, right? On that left-hand column. So you should obviously know they're out there. You should know if you're covered by them and be familiar with their provisions. But that is definitely another presentation for another day. You'll have to have me back for that. Now, neither temporary disability insurance or family leave insurance provide for job protection on their own. These are monetary benefits. They're an insurance benefit, right? They're a safety net for when an employee finds themselves in a situation where they're unable to work due to various reasons. There is a very good chance that when someone is eligible for these monetary benefits, they will also be eligible for some type of job protection from one of those laws listed in that left-hand column, right? So we see overlap. And then finally, you'll notice down at the bottom, we have New Jersey's Earned Sick Leave Law, kind of down by its lonesome self, right?
I wanted to know if you had some time today to go through a report for me and just filter, because I'm on a webinar now and then I have meetings through to
I
the
don't
end of the day.
know. If someone, Shamita, I think your microphone is unmuted. I don't know if Jackie, you have the ability to mute. I don't think that I do.
Yes, I do.
Okay, thank you. So New Jersey's Earned Sick Leave Law, again, I have it down there at the bottom. And again, that is because that is the one law that provides for both job protection and money, right? So it's both. It's unique in that way. And here you can see the qualifying reasons for leave. So again, disability is for the employee's own non-occupational injury or illness, either physical or mental, and it includes pregnancy and childbirth recovery. FLI provides for benefits when an employee needs to bond with a newborn or a newly placed child, either a child that was placed with them for adoption or for foster care. It is also available when your employee needs to care for an ill family member, a family member who has a serious health condition, or when a family member or the employee is a victim or a survivor of domestic or sexual violence. So foster care, and caring for a victim of domestic violence, those are relatively new aspects of this law. There was a pretty substantial overhaul to family leave insurance, as well as the Family Leave Act. Again, we're not really getting into that today, back in 2019. So as I go through this morning or this afternoon, I'll be pointing out what provisions have changed, right? Because for those of you who have been administering this for the past 14 years, but maybe you haven't had any claims recently. So there are changes. So I always like to point out what the changes are to make sure everybody is current. When it comes to caring for a family member, it's very important to keep in mind that caring is not just physical, physically caring for someone. It's also providing for emotional support, visitation, transportation, or if your employee needed to arrange care, and other assistance with daily living. So I'd like to point that out because I find that sometimes we'll get questions that, look, our employee's father is in the hospital and he's in the ICU and he has, the best doctors and nurses helping him. Why does our employee need to be off of work? They're not caring for their father. The hospital staff is caring for their father. But just being there for that person, just being bedside, just holding their hands, is enough to qualify for family leave insurance benefits. And then we have the New Jersey Earned Sick Leave Law. This law outlines 5 fairly broad reasons that an employee can take time off.
Yes,
including
6 when I had no lane space.
Oh.
Including caring for their own or a loved one's physical or mental health, addressing domestic violence against them or a family member, attending a school-related conference or event. So that's one of those things we don't necessarily think of sick leave to go to a meeting at a child's school, but that is absolutely covered within the law. And then quarantining and caring for children when their school or childcare is closed due to a public health emergency. So interestingly, this part about quarantining and the public health emergency, this law, as I mentioned, it took effect in 2018, right? Who knew where we would be 2 years later? So we saw this law utilized a lot once we hit 2020, specifically for that purpose. Okay, I'm taking a quick look at the chat, but I think we're good. Okay. So who is a family member for family leave insurance and earned sick leave purposes? I kind of jokingly always say, well, who isn't a family member? And that is because an employee can claim these benefits when they are unable to work and they need to care for any one of these relationships, right? Siblings, grandparents, chosen family, others related by blood. And the last bullet point here is sort of this catch-all for anyone that the employee considers to be family. So now, prior to that 2019 overhaul, family leave insurance was only available to an employee when they needed to care for a child, spouse, or parent. So again, when that law was overhauled, this was one of the areas that was greatly expanded upon. Also worth noting here is a child of any age, right? It doesn't have to be a child who is under the age of 18. Okay, I'm looking at the chat, so just bear with me one moment here. If the child is an adult, yes, if adult children are, for purposes of family leave insurance, they are covered by this law. For the earned sick leave law, that's an interesting question. I haven't fielded that yet, and I think I would want to bounce that off of the Department of Labor to see. So I would say that that's probably very uncommon Because most of the time, once a child is in college, they're 18 or older. And I don't know that the school would be requesting the parents' permission. I think that would be sort of an outlier, like not common. But good question. I can double check on that and follow up, certainly. The event is a football game. No, I don't think that would be, I don't think that would be a permissible reason to use earned sick leave, that no one is requesting their presence there as, you know, as they would if the child was having an IEP review or a 504 review in the classroom. That is my best guess on the football game. Okay, so I'm going to put earned sick leave on the back burner for now, and we can take a look at TDI and FLI, some of the nitty gritty when it comes to these laws. So to be eligible for temporary disability or family leave insurance, the employee must have earned a certain amount in New Jersey covered employment during their base year. So this is different than establishing eligibility for FMLA or NJFLA, right? Those laws require that the employee have worked for you for a year, that they worked at least 1,250 hours or 1,000 hours in the case of NJFLA. That is not the case here, right? This is not based on how long they've worked. It's based on their earnings in their base year. So what is a base year? A base year is the first 4 of the last 5 completed calendar quarters. This is the same time frame that unemployment would use to establish a claim and determine how much an employee would be eligible for. And the earnings in this base year period can be with any New Jersey covered employer, not just you. So if you had someone who was a relatively new hire and they had a reason to go out and collect, they could very well meet the eligibility criteria because they had other New Jersey employment before they started working for you. So again, you know, my point here is that this isn't based on time worked, but earnings with New Jersey covered employers. I swapped this handy dandy chart directly from the myleavebenefits.nj.gov website. I am a huge fan of handy dandy charts, and I thought it was worth sharing in case you too are a huge fan of handy dandy charts. And you can see if the employee were to file their claim this month in March of 2024, the state is going to look at the wages earned between October 1st, 2022 and September 30th, 2023. Again, that's the first 4 of the last 5 completed calendar quarters. Now, if for some reason a worker does not qualify using this standard base year period, never fear. The law provides for all of these alternate ways to calculate the base year. So I'm not going to get into detail on it. There's actually a really great explanation of it up on the DOL's website. But essentially, the Department of Labor has the ability to move around the base year. They could look at the 4 most recently completed quarters or the 3 most recently completed quarters. You know, I kind of joke that they're in the business of paying benefits, and they find a way to pay the benefits within the law, right? I mean, it's within the statute. The DOL is just implementing it. But they do their best to figure out how they can pay out those benefits. How much earnings must they have in that base year? So to qualify in 2024, an employee must have worked 20 weeks in their base year and earned at least $283 per week. Or there's an alternate test. The alternate test would allow them to qualify if they earned a total of $14,200 in their base year. These numbers generally do adjust annually. And I want to stress, the state figures all of this out, not the employer. But I do like to go through it because I know that many of you help employees through this process. But ultimately, these benefits are between the employee and the state, or the employee and your private carrier. So how much do they get if they are determined to be eligible for benefits? So the benefit amount that an employee receives is determined by dividing their base year earnings by the number of base weeks in the base year. That provides what they would call the average weekly wage. And the weekly benefit amount would be 85% of that average weekly wage, to a maximum of $1,055 per week for claims that are filed in 2024. So that's like a really definition dense sentence or two that I just rattled off. So I find it helpful to look at examples. So let's say you had an employee who was paid an average wage of $800 per week from the company. That was their their weekly salary, let's say. And that was the amount over the course of their base year, $800. Their weekly benefit amount is going to be 85% of that, which is $680. And that's how much the state would pay out for each week of their claim. If, on the other hand, you had someone who was a higher wage earner, let's say my example here is they earned $1,500 per week over the course of the base year, they're actually going to max out at the $1,055, right? Because 85% of 1,500 is going to be 1,275. That's higher than the max. So in this case, the most that they would get would be the max. Some of you may be thinking, Amy, I thought that disability only paid out 66%, 2/3 of the average weekly wage. That used to be the case, right? And that was another one of those overhauls that happened in 2019. They changed the formula from 2/3 to 85%. And the maximum amount of benefits that an employee can receive. So under temporary disability, the most an employee can be paid for each period of disability is either going to be 1/3 of the total wages earned in New Jersey covered employment during their base year, or 26 times their weekly benefit amount, whichever is less. So what that means is that in most cases, for your ongoing employees, right, the employees that have been with you for a long period of time, benefits are going to be payable in most cases for a maximum of 26 weeks. But if you had an employee who had limited earnings in their base year, maybe they're a new hire, they just moved here from Arizona, you're their first and only New Jersey employer, then they may be limited to 1/3 of the wages earned in the base year and not actually receive the full 26 weeks. I know YMCAs often hire a lot of minors as well, right? So this is a provision that might kick in for them as well because they don't have extensive earnings in New Jersey employment. You might be their first employer, like you were for me. For FLI, it's a little bit different. So how they claim the benefit will determine their maximum benefit amount. So an employee can claim their family leave insurance benefits all at once, or they can take their time intermittently. If they claim their benefits consecutively, right, they take it all at the same time, they would be entitled to up to 12 weeks of benefits in a 12-month period. If they claim their benefits intermittently, they're going to be limited to a total of 58 days, which is sort of the equivalent of 8 weeks. So it's important to know that once they establish their claim and they start collecting their benefits, if they return to work, even if it is just for one day, that claim now becomes an intermittent claim and that 8-week limitation kicks in. Okay. And the state views a week as 7 days. So when they pay out FLI by the day, it will be 1/7 of whatever that weekly benefit rate is. Okay. Any questions on Any questions on that before I move on? That sometimes I find some of this is very dense on the definitions, and I'm happy to take questions at any time.
Amy, there's a question in the chat about whether or not an employee can backdate a sick leave request.
They have already taken and not initially requested. So let's touch on that when we go back to earned sick leave. Can they backdate the sick leave request? I think that's going to depend on a number of factors, including how you as an organization provide the earned sick leave. Is it a standalone policy? Is it part of a PTO policy? Do you normally track the reasons for leave? So I think that's not a black and white answer to that. I think there's other things that would come into play. And why don't we hold on and we can discuss it further as we get into more in depth in the earned sick leave. Okay, so employers can pay the difference between disability benefits or family leave insurance benefits and the employee's regular wages without it impacting benefits. So some companies will do this as a matter of policy. So for example, you may have a policy that says when an employee is out on disability, we as an organization will pay 1 week of salary continuation for every year that the employee has been employed with us. And that salary continuation is the difference between their normal salary and the amount that the 85% that the state would pay out. Other organizations allow employees to use their PTO to supplement these benefits. So they have this bank of PTO, and the employee, it's hard, right? Surviving on 85%, they're used to having 100% of their salary. So some organizations will allow them to use their PTO to make up that 15% difference. Either one of those is just fine, and neither one of those is required, right? These are just some options. What's key is that if you do supplement the benefits, it doesn't result in the employee being paid more than they would have earned had they been working. So they couldn't be out collecting disability benefits, for example, and receive a full day of PTO, because now they've had a windfall, right? They've made more money on disability than they would have made had they been at work that day. So that would not be permitted. But paying that difference is perfectly fine. But the most frequently asked question that we get is, can we require that the employee use their accrued paid time while they're out on either collecting temporary disability benefits or family leave insurance benefits? And the answer is, it's complicated. This is one of those areas where we see the intersection, right? The overlapping of multiple laws that come into play. So I'm going to start with FLI because that is pretty straightforward. The New Jersey Department of Labor is clear that an employer may permit, but may not require an employee to use their accrued paid time. So if the employee opts to use their accrued paid time, it does not reduce the amount of FLI that they're entitled to. So for example, if you have an employee who opts to use 2 weeks of PTO and then claim their FLI benefits, they will still have a full 12 weeks of FLI benefits available to them as long as they take that time off consecutively. So, again, this is one of those areas that changed within the past few years. It used to be that the employer could require the employee use up to 2 weeks of accrued paid time. And if you did that and reported it to the state would reduce the amount of benefits that they were entitled to. Before the overhaul of this law, employees used to get 6 weeks of FLI. Now it's up to 12 weeks. But when it was 6 weeks, if you had this policy that required the employee to use their PTO and you reported that to the state, instead of paying them out 6 weeks, the state would pay them out 4 weeks. That has all gone away. No longer can the employer require it. If you allow it, because the employee requests it, then they still have the full 12 weeks of benefits available, again, as long as they don't take it intermittently. Under temporary disability insurance for private employers, there is nothing in the TDI law that specifically prohibits an employer from requiring the use of accrued paid time. So if you do require the employee to use their accrued paid time, the state would not pay benefits for that period of time that you're paying them, right? Again, they're not going to allow for that windfall. And it's actually the employee's responsibility to report those wages to the state, okay? But with all of that being said, nothing exists in a vacuum, and we have to be mindful of other laws that come into play that might affect our ability to require the use of paid time off in these scenarios. So we sort of need to like sidebar here for a moment, right? I know I said I wasn't going to talk about FMLA, but I always talk about FMLA. So of course I'm going to talk about FMLA. So for those of you who have more than 50 employees and who are covered by the FMLA provides that an employer can require or an employee can elect to use their accrued paid time during an otherwise unpaid leave of absence. When someone is eligible to collect either TDI or FLI, they're not out on an unpaid leave of absence. That is going to be considered a paid leave of absence. And as such, the employer would be prohibited from requiring, and the employee would be prohibited from electing to use their accrued paid time. So while there's nothing in the temporary disability insurance benefits law that prohibits you from requiring the use of PTO, you should be aware of other forces in play, right? Specifically the FMLA, if that applies to you. Now, with respect to New Jersey's earned sick leave law, which again, we haven't really gotten into yet, but that law is clear that an employer can never compel the use of accrued paid time. And that is the case whether you have a standalone sick leave policy or if your sick leave is included in your PTO bank, okay? Just looking at the questions, what should I be sending to employees on maternity leave for their return to work date? So I'm going to talk about maternity leave in just a few minutes, so we can take a closer look at that. This slide is a summary of the employer's role in all of this. So, number one, you're required to participate, right? We covered that. Does a law even exist if you aren't required to have that poster up on your poster wall, right? So double check, make sure that you have, they are two separate posters. Make sure that you have FLI and TDI up there. They are available at no charge on the Department of Labor's website, or you could always email me and I'm happy to send you a direct link to those. I know that many of you probably purchased those all-in-one posters from the various groups that sell those. That's fine. You just want to make sure that both of these laws are included there. You also need to provide employees with a written copy of notification at certain times. So upon hire, upon request, and whenever an employee notifies you that they're taking time off to bond with a child or care for a seriously ill family member. And what's nice is that you can use that same poster for purposes of distribution, which makes it easy. So, even if you have one of those all-in-one posters up on your wall, if you go to the DOL's website and print out that one-page poster, print out on 8.5 by 11 paper, you can give that to the employee, and that meets your notice requirement. If you have new hire orientation and you have folders that you put together for your new hires, stick a copy of it in there and you can check the box that you've complied with that. You are also required to report employee quarterly earnings to the state. My understanding is that if you're using a payroll provider, they typically take care of this for you. You want to closely monitor the benefit payouts that employees receive, right? You'll receive notice from the state when they pay out the benefits. And, you want to take a look at what they're paying out. Does it seem right? First of all, does this person even work for you? You would be so surprised how many times we get questions that, the employer has gotten a thing from the state saying that they've paid out benefits and they have no record of this person ever having worked for them. So you want to review it and notify the state if something seems inaccurate. If the employee is a low wage earning employee, but yet they've been determined to have this very high weekly benefit rate, that might be a red flag. So again, you could notify the department. And they will say that they count on employers to partner with them in that way. And you want to let employees know where they can file their claims. So the myleavebenefits.nj.gov website is where they would go. The Department of Labor is constantly updating this site. I will tell you, I am so impressed with the job that this administration has done in beefing up that website. When our members reach out to me and ask a question, I'm usually pulling up the website because probably in 94% of the cases, I'm able to find an answer directly on the site. It really is very comprehensive. They have a lot of great FAQs up there. They have the maternity timeline, which I'm going to show you in a minute as well. A great resource. It's really a great website, and they're constantly improving it. I was down at the Department of Labor last week or 2 weeks ago at a meeting, and they are working with the Department of Innovation in New Jersey to continue to modernize the process from both the end user experience, the claimant experience, right, when the employee files the claim, but also making sure that employers have the information that they need as well. So new parents. So before we go to earn sick leave, I wanted to kind of have one last segment here on what to expect when your employee is expecting, right? Because in a pregnancy situation, things tend to get a whole degree more complicated, trickier, because both TDI and FLI are implicated in most cases. So first, I'll mention that both parents get to receive FLI benefits to bond with their new baby. And they can claim those benefits at the same time, or, first one, then the other, or, really however the employee wants to claim it, as long as it's within the baby's first year. For the birthing parent, who I'm going to refer to as mom, it's important to note that she will have eligibility under both laws, right? First, because when she first goes out of work, she is going out because she is disabled due to the advanced pregnancy, and she's going to be eligible to collect those temporary disability benefits. Generally, it's for 4 weeks before the baby is born, but that is a rule of thumb. Every situation is different. And then as she recovers from having given birth, it's common for the doctor to indicate that she'll be disabled for 6 to 8 weeks afterwards. 6 weeks for a normal birth, up to 8 weeks if it was a cesarean. So in that example, 4 weeks before, and we'll say 6 weeks after, 10 weeks of her time would be temporary disability benefits due to her own disability related to the pregnancy, giving birth and recovering. Then the doctor says, okay, you are cleared to go back to work. And she says, well, no, I want to stay home. I want to claim my FLI benefits for the purpose of bonding. So it's important to know that FLI will never run at the same time as TDI, right? They're always stacked. They don't run simultaneously. So what that might look like is this. Mom goes out on disability 4 weeks before the baby is born. The doctor indicates she needs the 6 weeks after. So those 10 weeks of TDI benefits, you could see represented by the pink bar there. And then the doctor releases her. and she decides that she wants to stay out to bond, if she takes this time consecutively, she will have up to 12 weeks. So in this example, mom has 22 weeks of paid benefits. So now again, we're gonna, we have other charts that I can provide for you if you reach out to me on how the FMLA figures into this and how the NJFLA figures into this. And also keep in mind, mom does not have to take those 12 weeks immediately following her disability. Doctor may say you can go back to work, and she returns to work. And maybe she's going to save her FLI benefits to use at some point later in the year. Maybe she wants to save them to be home over the summer and bond with the baby at that point. Maybe she's going to return back to work after giving birth because her partner is home bonding with the baby at that period of time. So, just be mindful that it doesn't have to be all at once. And this is just one example of how it might play out. I do find in talking to a lot of employers that many employees try to maximize the amount of time that they're able to have off immediately following the birth. So that's why I go with these examples. And there's the FLI benefits. So this is the maternity timeline tool that the DOL and Department of Innovation have come up with. It's kind of neat. It is specific to mom, right? And it asks questions like, do you plan to stop working before the baby's birth? And what is your due date? And then it has all of these other questions the employee goes through, and based on their responses, it kicks out a timeline. So I did copy and paste the site on the slide as well. And I'm happy to make the slides available. I can send them to Jackie if that's okay. And then, if you wouldn't mind distributing them, I'm happy to share them. But again, this is all up on the DOL's website. It's a really great tool to use. You could, even if you sit down with your employees when they come to you and say, okay, what am I entitled to? What do I get? This is a great place to start, to sit down and go through this process. You're getting it directly from the DOL based on that employee's situation. So any questions on anything we've talked about so far? Because I'm going to switch over to New Jersey earned sick leave, but I want to wrap up if there's anything outstanding on temporary disability or family leave insurance. I'm going to take a sip of water too. Okay, no questions. We will move along. So as I mentioned at the start, New Jersey's earned sick leave law is relatively new to the scene. It was enacted just over 5 years ago in 2018. I'm guessing that most of you were providing sick leave prior to 2018. But it was estimated that over 30% of workers did not have access to paid time off when they were sick. And this number was even higher for those in low wage earning industries. So the legislature enacted this law to ensure that employees had time off when they needed it. And what's really important to note here is that this law applies to nearly all employees, full-timers, part-timers, temporary workers, seasonal workers, per diem workers, which is wild. And it applies regardless of the size of the employer. So, I realize most YMCAs are probably relatively large employers, but, an employer who has 5 employees or 10 employees, they are also subject to this law in New Jersey. Employees can use this time to care for themselves or a family member, as well as those other reasons that we touched on at the beginning. You are able to use an existing PTO policy to comply with the mandates of this law, provided that your policy meets all of the requirements of the law. And I'm going to talk a bit more about that because I have some cautions that I always like to give there. And just like with temporary disability and family leave insurance, the New Jersey Department of Labor oversees enforcement of this law. The law's definitions are incredibly broad in terms of who's covered. Basically, if you are an employer in the state of New Jersey, you are a covered employer, at least if you're a private employer. There are some exceptions for public employers. I won't get into that. But essentially everyone else is covered, again, regardless of size. So if you have 2 employees or 2,000 employees, if you're operating here in New Jersey, this law is going to apply for you. And that definition of employee is equally as broad. As you can see, an individual engaged in the service to an employer in the business of the employer for compensation. And there are some exceptions. They're very limited and narrow in scope, but I did put them there on the slide just for reference. And the fundamental requirement of this law is that employers must provide up to 40 hours of earned sick leave per year to each employee. And there's 2 acceptable methods for providing this benefit. So you can either have your employees accrue their time, and the accrual schedule is 1 hour for every 30 hours worked. So they would accrue 1 hour of earned sick time every time they worked a full 30 hours. Or you can choose to advance them their sick time. So that's when the employer would provide the employee with the full complement of earned sick leave on the first day of your benefit year. The benefit of the advancing method is that it allows you to skip over all of that accrual math of the 1 hour for every 30 hours worked. Whichever method you use, you can impose a 120-day waiting period before a new employee can begin to use their time. Now, if you opt for the front load method, questions will sometimes arise as to how much time we must front load to part-timers or to like a mid-year hire, right? And the DOL weighed in on this, and they've indicated that you can indeed prorate their time, which is great. And you can prorate it based on the time you anticipate they are going to work during the benefit year. The caveat is that if you advance these individuals less than 40 hours, based on what you anticipate their schedule is going to be, you're still going to need to track their time to make sure that you've given them at least the equivalent of 1 hour for every 30 hours worked. So essentially, what they're saying is, yes, you can advance it. Yes, you can advance less than 40 based on the anticipated schedule, but you need to make sure that the accrual doesn't fall below the statutory accrual rate. So a side note here, let's say you hire someone halfway through the benefit year. So and we'll say your benefit year is January through December. So you hire them in June. Don't assume that you can just front load them 20 hours. The thinking here being, well, they get half of the earned sick leave that they should be entitled to. You know, if they were here the full year, we would have given them 40. In this case, they're here half the year, so we'll give them half of the earned sick leave. We'll give them 20 hours. That's not necessarily going to be how the math plays out, right? Because of that 1 hour for every 30 hours worked formula. So if the employee is hired in June, and assuming that they work a 40-hour work week for the remaining 26 weeks of the year, they would be entitled to 34.66 hours of earned sick leave, not 20. Okay, so you need to watch the math. You always have to do the math to ensure that they are getting the full entitlement that they're eligible for. Now, leave can be either foreseeable or unforeseeable. You know, basically, does the employee need to be out for a reason that they know about in advance, or is this an unexpected absence? So you can require that an employee inform you up to 7 days in advance of any foreseeable absences, provided that you inform them of this requirement. So in other words, if you're going to require that they give advance notice of their need for foreseeable leave, make sure it's in your policy, right? Put the employees on notice of the requirement. And if the leave is unforeseeable, for example, their child wakes up sick one morning and they need to stay home with them, then you can require that they provide notice as soon as practicable. There are only 2 instances when the employer can request documentation for sick leave. So first is if the employee is absent for 3 consecutive days, or if the employee uses an unforeseeable sick day during a blackout period. So what's a blackout period? Blackout dates are established by the employer, and they are dates when the employee can specifically not use foreseeable sick days. The regulations limit these blackout periods to verifiable high volume periods or special events where the granting of a foreseeable leave would unduly disrupt your operations. So a blackout period doesn't mean that the employee can't call out sick. Rather, it means that they can't schedule a sick day, right? So if you had an established blackout period and the employee scheduled a doctor's appointment, you could tell them, no, we're not approving that day. That is an established blackout period. If an employee nevertheless calls out sick during that blackout period, they're entitled to the sick day. The difference here is that now you can ask them for documentation, right? Even if they're only out for that one day. So the general rule is that you can't ask for a note unless the employee is out for 3 days, unless they call out sick during an established blackout period. In that case, you can ask for documentation, even if it was only a 1-day absence. As I mentioned, an employer can use an existing paid time off policy to comply with this law. If you do this, I'm going to provide my strong cautions, right? Because the regulations require that all of the paid time off in your paid time off bank meets or exceeds all of the requirements under the law. So what this means is that employees would have to be able to use their PTO time for all of the reasons provided for under the law. They have to accrue or advance in a way that's at least as generous as what the law provides for. We haven't yet talked about carryover and payout provisions, but they would have to be the same. And this quote on the bottom of the slide comes directly from the Department of Labor in their regulation commentary. An employer who wishes to deviate from any one or more requirements of the Earned Sick Leave law always has the option of splitting its leave policies so that one is compliant with the law and essentially the other policy you can administer as you see fit. So, sometimes I'll talk to employers who they use a more generous PTO policy. The employee can use the time for vacation, personal, sick time. The employer doesn't care, right? It's simply a bank of time that the employee has access to. But sometimes they want to carve out and say, well, the earned sick leave provisions of the law only apply to the first 40 hours of PTO. That is not going to fly. That's what the DOL is saying here. Nor will a sub-account within your PTO policy, which is just for sick leave. So, I always encourage employers to really think about whether it's worthwhile to include your sick time with your other paid time off, because the DOL is telling you here in this pretty straightforward way that if you don't want all of the rules to apply to all of the time that you're offering, split your policies. So I'm personally a very big fan of having 2 separate policies. Obviously, you need to decide what's right for your business, but here are some more things to consider about this. So let's say you offer a more generous PTO policy that provides well in excess of the law's required 40 hours. So in my example here, for number 1, the employee gets 120 hours of PTO. And let's say they use 100 hours over the course of the year. Maybe some of those 100 hours were for sick time, maybe not. It doesn't matter. Either way, there are 20 hours left in their bank at the end of the benefit year. Those 20 hours would have to either be paid out or carried over according to the DOL's position. It doesn't matter that the employee used well in excess of 40 hours. And it doesn't matter that you can show that they had at least 40 hours that were specifically used for sick time, right? They're saying all of the rules apply to all of the time in the bank. In example number 2, we say an employee has 25 PTO days under your policy, right? You give 25 days. Again, vacation, sick, personal, all lumped together. All 25 of those days could be used for earned sick leave purposes, meaning an employee could have 25 unplanned and unscheduled absences. So let that sink in for a minute, because that's a pretty big deal. And that's probably not consistent with how most employers are administering their policies. Same thing with asking for documentation. So that's example number 3. If your policy provides for 25 days and you have an employee who is using those days for unscheduled absences, right? They're sick, their family member's sick, they have that, school meeting. You're going to be limited to when you can ask for documentation for all 25 of those days. Again, all of the provisions of the law would apply to all of the time in the bank. So there's a question. So can't there be a use it or lose it policy on vacation? Yes, you can absolutely have a use it or lose it policy on your vacation, as long as your vacation is not part of a PTO policy that is also providing for earned sick leave. So if you have separate policies, a sick leave policy, which is in compliance with the law, a separate policy for vacation, maybe you have a separate policy for personal time off, those vacation and personal policies can be administered however you like. You want to make sure that you clearly express the terms and provisions in your policy, but that is something you are giving as a benefit. That is not required. Vacation is not required under the law. So you can administer those as you like. Where it gets complicated for employers is when they lump everything together into this one PTO policy, paid time off policy, that includes sick leave, personal time. Sometimes it includes holiday or bereavement, any paid time off that the employee takes. That's where limitations would come in. So if you have a separate standalone vacation policy, yes, you can make that a use it or lose it policy. Again, you just want to make sure that you stipulate whatever the requirements are in your policy so that the employees have a clear expectation. What happens when we suspect that an employee is abusing their time off, right? This is always the big question. They've called out sick every Friday in July, and there is no way that's legit, right? Like, we know that. So the Department of Labor's regulation reads in relevant part, all requests by employees to use earned sick leave shall be treated by the employer as presumptively valid. Now, I think that this is a little different than you having some type of proof that an employee is using a sick day for an illegitimate purpose. You see them on the Jumbotron at the Yankees game, or they post that picture of themselves on Facebook water skiing when they should have been at that doctor's appointment. Then perhaps you discipline. But absent any type of material proof, the absence is presumed to be valid. The employer gets to decide the increments of time in which leave is taken. So for example, you could say that earned sick time must be used in full day increments or in half day increments. You could allow it to be taken by the hour. This is your call. And again, this is probably something you want to double check your policy to see if you have that in there. Always be mindful, you can't require an employee to take more sick time than the hours that they would have worked on a shift. So you know, if you say that sick days are paid out in full day increments, but you had an employee who was only working let's say a 6-hour shift, you couldn't require them to use 8 hours of sick time if they were only scheduled to work a 6-hour shift, which kind of makes sense. The second bullet here, paid sick time must be paid at the employee's same rate of pay. Again, that's fairly straightforward. Unused sick time. Oh, yes, a question. A question. Feel free to unmute yourself.
Hi, can you hear me now?
Yes, yes.
What if it's the opposite? We can't require them to take more than their shift, but what if they request more than their shift for that one time they're out?
No, you would only have to provide them with what their shift would cover.
Okay, thank you.
Great question. Great question. What happens to earned sick leave at the end of the benefit year? Well, it has to either be paid out or carried over. Up to 40 hours of unused hours could be carried over into the next year. But there's no requirement that you pay out the unused time at the end of employment. So, you know, sometimes employers will have these policies that say, you know, we will pay out your unused time, provided that you give proper 2-week notice and you're you know, you return all company equipment, and, you know, you can put whatever stipulations you want on that. And if the employee meets those stipulations, you can pay out their earned sick time. You are not required to pay out the earned sick time when they leave employment. You can choose to do so. If you choose to do so, you may want to consider putting some stipulations on the payout of the time. But you're not required to pay out the time. Some organizations will have policies that say, once you give your 2-week notice, we don't allow you to use your sick time. That's a problem, right? Because remember, presumed to be valid, right? It is presumed to be valid. So if the employee provides 2 weeks notice, they're working out their notice period, and they call in sick one day, that is an absence that is presumed to be valid. That was something I know prior to this law was a fairly common provision in employer policies, but that gets tricky because of that presumptively valid clause. So payout and carryover, it looks a bit different. I'm just checking my time. It looks a bit different based on how you provide the time off. So if you are an accrual employer, the statute indicates that the employer may provide an offer of payout. And if you do provide an offer of payout, the employee has 10 calendar days to either accept or decline your offer. If the employee agrees to the payout, they get to select whether they want to be paid out 100% of the time that remains in their bank or 50% of the time that remains in their bank. And if they decline the payout, or they only agree to a payout of 50%, the unused time would carry over into the next year. And then it's available immediately for them to use. And I think that carryover in this situation, when you're an accrual employer, it makes sense, right? Because let's say at the end of the benefit year in December, the employee has 16 hours of earned sick time left, and they know that they have an upcoming doctor's appointment in January. If they accept your offer to buy back their time, they're going to be out of luck for those days when they need off in January, because they have to now accrue more time to build up their bank again. So that's a reason why an employee might decline the payout of the sick time and instead allow it to carry over, because that carryover is immediately available to them in the next benefit year. They don't have to wait for more time to accrue. When time is front-loaded or advanced, you also must either pay out any unused time at the end of the year, or carry it forward. So it's in both cases, whichever method you use, it is the employer's choice whether to make an offer of payout. You are not required to make an offer of payout. If you choose to, you know, the rules in this left-hand column, if you're the accrual employer, that is what would apply. If you choose not to, then the time would simply carry over to the next benefit year. If you're the advancing employer, all of this business of the employee having 10 days and they get to choose a full payout or 50% payout, all of that goes away. If you pay it out, then you simply pay it out. And you, as the employer, get to determine it would be the full payout. But this issue of, let's say you decide we don't want to pay it. We don't want to pay it out. Why would we want to pay it out? That's fine. You don't have to make an offer of payout. What happens then is the time carries over into the next benefit year. So we talked about for the accrual employer, why an employee might want to do that. But for an employer who uses the advancing method, this whole issue of carrying over time is curious because the statute provides that an employer does not have to allow an employee to use more than 40 hours of earned sick leave in a benefit year. So if you carry over their unused time from one year to the next, and you're advancing them their full 40-hour allotment for the next year, it would seem that they now have access to more than 40 hours. So we refer to this as ghost hours, right? Because they exist on paper, but they don't exist in reality. It's tough because, you know, again, so let's go back to that employee who had, let's say 6 hours left at the end of the year. If you don't offer to pay that out, those 6 hours would carry forward to the next benefit year. And as an advancing employer, you're advancing them their full 40 hours for the new year. So it would seem that they have 46 hours in their bank and available to them. However, the law is very clear that you never have to allow an employee to use more than 40 hours in a year. So it's confusing. Employees don't understand it. Employers don't understand it because even though it's carrying over, it's essentially carrying over for record keeping purposes to show that you carried it over. But the employee will only have 40 hours to use in the upcoming year. So it's, again, we call them ghost hours. They're not real. You could choose to make them available. You can choose to allow the employee to have more than 40 hours. They could have the full 46 in that example. So it's just tough because I find this is an area that employees don't tend to understand why they can't access their carryover time if you're an advancing employer. Any questions on that? So when an employee is eligible to use their earned sick leave, the employer is prohibited from requiring the employee to make up the work. You're prohibited from requiring them to work additional hours. You would not be required to you could not require the employee to search for or find a replacement to cover their shift for the time that they're missing. And you're not able to require the employee to use an earned sick leave. That one can be a bit troublesome. And you can't retaliate against an employee for using their sick time. But going back to that third bullet point, the statute indicates that an employee shall not be required to use earned sick leave. So, you know, thinking back to our question from earlier, right? Can the employer require the use of PTO? The answer is no, if the PTO is inclusive of earned sick leave because of this provision. There are strong anti-retaliation provisions included in this law, including a rebuttable presumption of unlawful retaliation. So a rebuttable presumption is a legal principle That means that something is true unless someone proves otherwise. So if an employee were to file a complaint or cooperate in an investigation, and within 90 days of that action, the employer took some adverse action against the employee, the law, the statute requires the Department of Labor to presume that the employer engaged in unlawful retaliation, and it would be up to the employer to prove otherwise. This slide outlines what happens if an employee is transferred to a different division or location. Essentially, they retain the right to all of their earned sick leave at the new location. If employees are separated from employment and then rehired, any unused earned sick leave must be reinstated if the rehire occurs within 6 months of the separation. So that's an important provision to keep in mind if you're hiring seasonal employees, right? Let's say you have staff come in for the summer months, and then maybe you bring them back, over the holiday break in December and January. That's less than a 6-month break in time. So you would need to reinstate any earned sick leave that they had previously earned that summer. The regulations go into a good amount of detail in determining if you're a successor employer. We're not going to go through any of that today. The law requires that we provide a notice to all employees, as well as conspicuously post notice on our poster wall. This notice is up on the Department of Labor's website. It's available in 12 languages in addition to English. And again, you can simply print it out and hang it up. This is a 2-pager. So if you're doing the 8.5 by 11, it will come out on 2 pages. You'll see on the form, you can kind of squint at the slide here, there is a place on the poster for the employer to fill out what your benefit year is. So, if you use the calendar year, you would want to put, January through December. If you use your fiscal year, you would put that. If you use the employee's hire date, that is an option as well. But you just want to make sure that you somehow indicate that on the poster. And finally, these are just some tips, because maybe you're going to go back and review your policies, and maybe you're going to consider splitting your policies. If you are, hopefully no one is starting from scratch, right? Hopefully everyone has policies at this point. The law is about 5 years old. But reach out to me, because EINJ has created model policies, and we have policies for both the employer who is the accrual employer and the employer who is using that advancing method. One question that we'll get is, can we use different methods for different groups of employees? And you can. So for example, maybe you want to say your administrative staff we will advance their earned sick leave to them. But our hourly program staff, we are going to have them accrue the time. That's fine. You can have different rules for different groups of employees. You just want to make sure that it's administered consistently within those groups. And that is what I have for you. So I'm hoping that you might have some questions for me. I can certainly hang around in case there are any. If there are no questions, my contact information is up there on the slide. You can reach out to me with any questions that you have, or if you're interested in EINJ membership, I'm always happy to chat about that as well. And I want to thank you. Thank you for having me here today.
Thank you, Amy. Are there any questions for Amy?
It was a lot of information. So again, if questions come up, at some point later, you have my email address there, my contact information, feel free to reach out.
I have a question, Amy.
Yes, please.
The sick leave law for part-timers is it's difficult. So it was almost like the question earlier. So if an employee can we require in our policy that in order to, well, we can't deny them their request, but if they don't request it, because we have a system that we require them to request their sick time, and maybe they'll text or they'll call their supervisor and say they're out, they're not feeling well. And we clearly say in the policy that as soon as you are able, as soon as you can, request it in the system.
Right.
And then 2 payrolls go by and they're like, oh, I forgot to request it. I want to put in for sick time for that day 3 weeks ago. Are we obligated and required to give it to them?
That's a good question. You know, so do you have a standalone sick leave policy or is it part of PTO?
No, it's standalone for all part-timers.
Okay. So in this example, and I'm going to restate it to make sure I understand it correctly. So the part-timer, they called out, but they never went into your system to request pay for that day.
Correct.
And now it's 3 weeks later and they're like, oh, remember that day that I called out? That was for an earned sick leave reason. I'd like to request my sick leave day. Is your policy clear that they must request it within a certain period of time?
Not within a certain period of time, I don't believe.
Okay.
And I need to double check, but I know that we have a policy that they must request it within the system so that it can calculate correctly.
Right. You know, the one thing that I would say just from a practical standpoint is you may want to approve that time as a way to draw down on their sick leave, you know, the time that's available to them, right? So if they had, let's say they had, 40 hours in their bank and they're like, oh yeah, I forgot to put in for that sick day, but I was sick that day, by allowing them to have that time, even though it's, a few weeks later, it makes that pot of time of it, that for future use,
right. I understand what you're saying.
Down on it.
Right. Okay. But
so that doesn't directly answer your question of can we deny it, right? Because
right.
I think that's your question. Can we say, no, you missed our deadline? I think that if your policy had a deadline, that they have to put in for it within a certain period of time, you would be in a much better position to make the case to the DOL if an employee were to complain about it. Not having a deadline, and it's a bit more discretionary, I could see that going either way.
Okay, so we are allowed to stipulate a time frame for them to request
it. Yeah.
Not that we're gonna deny it, but just we don't deny it, but we do want to set some boundaries as to how long and how far back, and for them to follow the policy.
Right, because you don't want to be paying out this time like 6 months later, right? Like it's just not administratively feasible. So I think I don't see a problem with you putting a deadline for requesting it in your policy. I will double check that with my contacts at the Department of Labor to see if they take any issue with that. So if you want to drop your email address in the chat, I can grab it and then follow up with you.
Okay, perfect. I will do that.
Very good.
Thank you, Amy.
You're welcome.
Any other questions for Amy?
I'm trying to think if there was anything else.
All right. Well, thank you all so much for participating in today's event. We really appreciate you, Amy, as well. And we'll see you next time.
Very good.
Thank you, Jackie.
Thank you.
Thanks, Jackie, for putting us together.
Thank you for having me. Thank you.
Thanks, Amy. Thanks, Jackie.
Take care, everybody.
Take care.
Bye.
Bye.
I finished.
Finally, I saw more data with the notifications.
You know why?
Can this end now?
Because why?